have modified it so they're not providing that. And it's really important for you guys to know that, because for a couple of reasons. First of all, you need to let your seller know that's how it works. And I think electronic signatures have been the very worst thing to happen to buyers and sellers, because all they do is click, 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 and sign, and they read nothing, right? So you're having to have these conversations with them. I want to tell you right now how this works. If they terminate, you're not getting a copy of the inspection report. And they might go nuts at that point. I want a copy. I want to know why they're terminating. Then you have the conversation about how, okay, well, this is, I don't care what kind of idiot you think that inspector is, you're going to have to disclose that information to the next buyer. It also means you're having to have the conversation that if there's a copyright language in there and you can't pass it along, you're going to have to transfer all that information into your property disclosure statement, because you can't just hand them the sheet, right? So you need to have these conversations. If they, at the end of the day, insist on getting that report, what are you going to have to do? You're going to have to counter, because the contract doesn't provide, they have to provide the report, right? So you're going to have to counter and say, if you want to terminate this, I want to see a copy of the inspection report on which your termination is based. All right, but these are the conversations you have to be having with your seller. In the event that they are objecting and asking for a cure, they only have to provide the section of the report on which the objection is based, so not the entire report, okay? Again, we're kind of minimizing getting these reports passed around to everybody, and if you explain to your seller what the benefit of not getting the report is, they might agree with you. As a seller, I don't want the report. I mean, I don't. I just, you tell me what you want me to fix, I'll fix it or we won't, but I don't want the whole report. Yes?
Do they still have the right to not get the report if the seller's the one that paid for it?
Yep, they absolutely do.
On behalf of the buyer?
Yep, it doesn't matter who pays for it, the contract said it doesn't have to be provided. So again, these are conversations you're having with your seller, and if they insist on getting it, you guys are gonna have to counter it, okay? Because that's the way it works. I find that 99.9% of the time that sellers and buyers are upset and end up in disputes over earnest money is because they didn't read the contract and they don't understand how it works. If you guys set their expectations when they go into it, they know what to expect, right? I'm not getting the contract. I'm not getting the inspection report. I know that because my broker told me I'm not going to get it, and I'm okay with that. And if I wasn't okay with it, I would have countered it and said I wanted the report, right? So you have to just educate them, because they're not reading this stuff, guys.
And does that same thing apply to appraisals? That same scenario?
Yeah, the same thing applies to appraisals, and especially when a seller pays for it, they think they absolutely are entitled to it, but that's not the case. If you're going to pay for it and you want a copy, that should be in a counter offer. I want a copy of the appraisal, okay? So if they make an objection, okay, they're standing at the crossroads. I'm either going to terminate or I'm going to object, and they choose to terminate. They choose to object and not terminate. They have to allow the seller the opportunity to respond, okay? What I was seeing, we were getting a lot of is they would choose to object and not terminate, and then before the seller even had an opportunity to respond to the objections, they want to terminate the contract. Oh, no, you had that opportunity. It was 3 days ago when you were standing at the crossroads, you opted to object and not to terminate, okay? So you're going down this path and you're going to give the seller an opportunity to respond. Now, once the seller responds, if they don't give them everything they want, then they can terminate. Okay? And that's where you get the seller going, wait. I didn't realize you were going to terminate it if I didn't give you everything you want. Let's go back. I want to give you everything you want now. Well, too late. Okay? So that's a conversation you're having with your seller. You don't want to give them everything you want. You don't have to give them everything you want. You can go back and tell them something else, but it puts the ball back in their court to terminate the deal. And you don't get to go back in time and say, no, I'll do everything you want. Okay? So just be aware that that's how the contract works. As you guys all know, if you don't come to resolution by the resolution deadline, what happens? The contract automatically terminates. Automatic termination of the contract. So what happens if you're a buyer's broker and you're coming up on that date and your buyer has told you, I want that house even if the seller's not willing to do anything, all right? We've made some objections. We're waiting for the seller to do something or say something. We haven't heard a word back from them. The clock is ticking, resolution deadline's coming, but if they come back and don't come back, with anything, I still want the house. You guys get to pull those objections off the table by the resolution deadline. You have to amend your ORW and pull them off the table. And you guys need to have your clients, your buyers, doing that, not you. I'll talk about that in a little bit when I talk about revocation of offers. You guys are transaction brokers, most of you. Anybody working as an agent here? Nobody works as an agent anymore, right? Unless you're a property manager. Which means you have, the benefit of that is that you have limited liability. You don't owe fiduciary duties, which are heightened duties up here, right? You don't owe those because you're a transaction broker. What do you owe? You owe broker duties, right? Something less than fiduciary duties. So that's all good. but it also means you don't have the kind of authority you have as an agent. You can't bind your clients, all right? So to the extent that you can get your clients doing these things and not you, the better, the better. And if you can't get them to sign something, for example, an amendment to the ORW, pulling them off the table, then get them to send you an email that says we revoke all of our objections that we made in our ORW, but forward that over to the other side. So it's your buyer who's making the call and your buyer who's saying it, okay?
I have a question.
Yeah.
For the resolution, does that mean like fully resolved, or that the seller then responds and then you can keep negotiating?
Nope, it means you have it, and we define resolution in the contract in the definition section, that really boring section in the very back of the contract is a written agreement between the parties as to how the buyer's objections will be resolved. So you have to have a written agreement as to how all of those are gonna be resolved. If you're coming up on the deadline, the seller doesn't respond to you that morning, the buyer wants to think it over, he doesn't know if he wants to terminate, he wants to go back with another offer, you need to extend the resolution deadline.
Okay.
Yeah.
So not only that their
That's not just their response, it's
Okay.
total agreement on how all of those things are gonna be resolved.
Okay.
Written agreement on how those things are gonna be resolved. We added some information to subparagraph J in the definition section, speaking of fixtures, yes?
I'm sorry, going
Yeah.
back on that, if they decide to move forward without doing an extension,
Mhm.
do you then have to do an extension?
You mean if they continue negotiations after the resolution deadline?
Yeah, like let's say after the resolution deadline they continue and then they agree to something, would you then have to do an extension?
No, if you come to an no, if you guys come to an agreement after the resolution, so whenever you guys pass a deadline, and this is very important as well, or somebody defaults or a deadline gets passed, if everybody's continuing along the path like everything's fine, you know, it's hard to go back and say, oh no, that wasn't fine 2 weeks ago. I have people say, oh, you know, they breached the contract 2 weeks ago and they didn't deposit the earnest money timely. Well, wait a second, that was 2 weeks ago. We've all been marching towards the closing table for the last 2 weeks, and you want to go back and call them out on a default 2 weeks ago? You can't do that, right? So it's going to be really hard if the parties have come to an agreement, right, and sign off on an agreement dated after the resolution deadline to go back and say, oh no, our contract terminated on the resolution deadline. Well, then what have you been doing for 3 days? What have you been doing for the last week?
Okay.
Talking about these issues, right?
Should still be safe.
Yeah, I mean, I think it's a hard argument to make. Should you not go and extend it even though it's after the fact? I just don't think it's that important at that point. I mean, if you have a resolution, then you have a resolution. The problem, if you don't come to a resolution, obviously, then all you're going to be left with is that resolution date, termination of the contract, earnest money goes back to buyer.
Yeah, okay.
So in the definition section, subparagraph J, fixtures, and we are kind of massaging this still, so we'll see how this goes. Bless you. Sometimes you have various components of a system, some of which are fixtures and some of which are personal property. One of the things I think about is the doorbell. You got something attached like at the wall, and then you have the Wi-Fi thing sitting on a table somewhere inside, and you can just pick that up and take it out, and it isn't attached to the property. So what we say in this section is that in the event that there are multiple components, some of which are fixtures, some of which aren't fixtures, the combination of all of it is a fixture. So if it all works together, if you pull the doorbell off and leave the Wi-Fi, that's not going to do you much good. And if you take the Wi-Fi and you leave the doorbell, that's not going to do you much good, right? So if it all works together, then it's considered a fixture. If any part of it is a fixture. Somebody said to me at the legal update, they talked about curtains and curtain rods, because I made also the example of the Murphy bed, because people have been known to leave the Murphy bed and take the mattress, right? Yeah, well, how are you going to use your Murphy bed without a mattress? You're going to have to go buy a new mattress. So arguably it falls under this definition. Then somebody, well, how can you use curtain rods if you don't have curtains on the window? So we're still kind of massaging that a bit, but we are trying to a lot of these things we try to address in the fixture and personal property section, but we can't address everything, guys. We have to have some kind of catch-all things to address some of these issues.
I have a question on that. So we ran across where they took the number for the house.
The number that was on the house?
Not on the house. It was in the ground. It was like a stick, but like it was buried. Would that count because it was like buried?
Yeah, well, I mean, the way we define, a fixture in our purchase agreement is if, you're disrupting the real property in any way by removing it, then it becomes a fixture, right?
Yeah.
So if you have to tear up the grass, arguably, and I'm sure they weren't big holes in the grass, but they were probably holes in the grass, that you had to disturb the real property in order to pull this thing off, then yeah, arguably it was a fixture. But it's really important, you guys, because some of these things are just gray and we can't address it all, is to, be talking to your sellers. Yesterday I had a broker tell me that the seller took a wood burning stove. They said it wasn't hooked up. It was just sitting there, but the buyers swear it was hooked up. And we have, it was a pellet stove actually. We have that in our fixture section. But you guys need to be communicating with your sellers about these things. Is there anything you're not leaving that I should know about, right? I mean, and if it's so obviously personal property, then, it's not a big deal. But if it's, even the slightly could be considered fixtures or is in that list of fixtures and they want to take it, you guys need to exclude it. You're going to have to counter and exclude it.
What about a safe?
A what?
Like a safe?
Well, that's the thing too. Some of those are bolted to the floor, right? And if they're bolted to the floor and you're disrupting the real property in any way, shape, or form, it's considered a fixture. But if it's not bolted to the floor, it's just sitting on a shelf or sitting on the ground in the closet, they can take it. There's no damage to the real property. It's considered personal property.
This window that we have, they looked like it was just sitting there.
Mhm.
When we did a walkthrough yesterday.
You saw damage. Were they
Well, no,
taking it?
he left the wrench
Yeah.
that he was unbolting it
Oh.
from the floor.
Oh.
I mean, whatever, the
Yeah.
buyers doesn't care, but I'm like, that's a fixture.
Yeah, exactly. Exactly. You can't
That's
do
the
that.
fact.
And that should have been a conversation the listing broker had, right? I mean, is there anything here that is in any way, shape, or form attached to this property that you want to take? Let's talk about that and whether we need to exclude that in a counter offer, okay? We have some language in paragraph 35 in earnest money. We added interpleader actions back in there since Fidelity is in the room. Well, Fidelity was in the room. So Fidelity is one of the few title companies that are still filing interpleader actions. They were really anxious to do it and were doing it very quickly, and I had a long conversation with Susan and I said, could you please just push it out and let them have some time to resolve these earnest money disputes. Interpleader actions, I don't know how familiar you are with those, but what happens is when some people are fighting about money, the person who has the money or has whatever it is can deposit that with the court. They initiate a lawsuit. They name the buyer and the seller as defendants in that lawsuit. And then the buyer and seller are forced to cross-claim against each other, sue each other, to determine who gets the money. And then the losing party pays the winning party's attorney fees along with the title company attorney fees for filing the interpleader action, which runs somewhere between $800 and $1,200, okay? So forcing people into litigation is not necessarily a good thing, especially when we're talking about $500, $1,000, $1,500 worth of earnest money, right? So anyway, Fidelity is doing that. They are waiting close to 6 months now to do it. They will send out a letter to the buyer and the seller and say, hey, we're getting ready to name you in a lawsuit and you're gonna be forced into litigation, so you might wanna resolve this issue. They're one of the few that do it. Most of them will not do it anymore. They will hold on to the money until 5 years has passed and then they can send it to the state of New Mexico as unclaimed property. They don't like doing that because it's an accounting nightmare for them, but they also don't like initiating lawsuits. But they do, it does happen. And for those, let me just, one final thought. I don't know, how many of you guys in here have used the Tom fee? Guys, use the Tom fee. You guys are having conversations, right, about the Tom fee? I know it's scary, it's new and scary, and it's gonna take a really long time for everybody to get comfortable with it. I created an information sheet so you can have these conversations. If you can use the Tom fee, you can get past the whole inspection period with earnest money issues. They can walk away at the end of the inspection period without any obligation to one another. And when we created the Tom fee, you're like, how do you sell this to people, right? I mean, on the seller side, how do you sell it to a seller? Well, it's easy on a seller side. What does a seller get when a buyer decides they don't want to buy the house and they object or terminate by the deadline? What does the seller get to keep? They get nothing if there's no Tom fee, right? They get nothing, absolutely nothing, right? So a seller says, well, I know it's not a lot of money, but I get to take my family out to dinner at, I don't know, Outback or something, right? I get something, because otherwise I'm getting nothing, right? So then how do you sell it to a buyer? I mean, the buyer's the one who's gonna lose the money completely. How many of you guys have been involved in an earnest money dispute in this room? If you haven't had an earnest money dispute issue, you probably don't recognize the importance of the Tom fee, okay? You have one earnest money dispute issue, you will recognize the importance of the Tom fee, okay? Because it doesn't matter how clear we make the language in the contract. You can't make people sign off on the distribution, and the title company is not releasing it without something signed off by both parties or judgment from the court, right? So a buyer goes into the deal, they terminate, they don't even want to ask for the seller to cure anything. The sellers all completely heard about that. I mean, I didn't even ask me if I would fix it, and that's ridiculous. This inspection report is ridiculous if they got one, they countered and got one, right? Or it was just sent over. And they don't want to actually release the earnest money. And so now the buyer is battling for earnest money that, you know, is very clear that they're entitled to get. Well, how do they get it if they're not willing to sign off and just give it to them? Well, you go to mediation, you go to litigation, you end up in court, right? I mean, if you can avoid all of that for $150, sign me up. Sign me up. I would do it 100 times over. The reason we enacted the TOM fee is to try to eliminate some of these earnest money disputes that the title companies are dealing with, the parties are dealing with, to allow them to walk away at the end of it, the end of the inspection period, without having to fight about earnest money.
Have you
So,
talked about getting rid of earnest money altogether and just doing Tom fee?
well, one step at a time. Yeah,
Right.
yeah.
Yeah.
I mean, I would love to
That would
see
make
that.
sense.
I would love to get rid of earnest money. I mean, earnest money serves a purpose in the sense that if you have a true breach of contract, right?
Right.
You've got some third party
That's-
holding money, and if you
Yeah.
do get your judgment from the court, you don't have to go try to collect that judgment from the buyer or the seller, right? Or from the buyer, right? Because then you got to garnish their wages and garnish their bank accounts. You can just take the judgment to the title company, they just release the funds, right? So there is a benefit to earnest money, and so it's not eliminated under the TOM fee arrangement. It's actually, we'd like to see it pushed out until after you get through inspections and then deposit the earnest money. So that's, you know, you guys, I encourage you guys to read the information sheet, to have these conversations with your clients, to let them make the decision, right? Because I'm afraid, honestly, I mean, we created the TOM fee, but I am afraid it could create liability for brokers in the sense that if you don't have these conversations and the buyers and sellers end up in litigation over earnest money issues, and they find out after the fact, hey, there was a way to avoid this. You know, there was a way that I could have avoided this earnest money issue if I could have just given a TOM fee. Why didn't we have that conversation, broker? Why didn't you tell me about that, right? So anyway, you guys, I encourage you guys to be open to the TOM fee, okay?
Does the
Yes.
Tom fee go straight to the seller?
It does. It goes directly to the
Regardless,
seller.
doesn't matter.
Doesn't go to the title company, it goes directly from the buyer to the seller, through the brokers. It can go through the brokers, or they can
somehow,
Venmo it
like,
or
be put into
PayPal it or
their
whatever.
list?
Huh?
Also, like, say like you do, I don't know, $2,000 deposit, and
Uh-huh.
like $500 Tom fee, can that all go together somehow, or is it?
Well, no, because the earnest money is going to the title company to be held, right, and then the TOM fee is going directly over to the seller. Yeah, so there's not any way really for it to be, you know, unless, you know, I guess it could all go to the, you know, you could send it all over to the title company, and you could do a distribution immediately of $500 of it to the seller, I guess, but I don't know why you'd want to necessarily run it through the title company. And title companies, some of them won't even touch it. They're like, oh, that's not for us. We don't deal with the TOM fee. And I know that was a lot of confusion at the beginning. It's supposed to go directly from the buyer to the seller. And like I say, through the brokers, or they can arrange to do it, you know, electronically, Venmo or PayPal or whatever. But I encourage you just to understand it. I think a lot of people don't understand it, and therefore they don't use it. And I encourage you guys just to try to figure out how it works and see how it might benefit your clients.
What's like 2 months?